What is fault? Fault is an improper act or omission which arises from ignorance, carelessness, or negligence. The act or omission must not have been meditated and must have caused some injury to another. Gross fault or neglect consists in not observing that care towards others which a man the least attentive usually takes to his own affairs. Such fault may, in some cases, afford a presumption of fraud, and in very gross cases it approaches so near as to be almost undistinguishable from it, especially when the facts seem hardly consistent with the honest intention. But there may be a gross fault without fraud. Ordinary faults consist in the omission of that care which mankind generally pay to their own concerns, that is, the want of ordinary diligence. A slight fault consists in the want of that care which very attentive persons take of their own affairs. This fault assimilates itself to, and in some cases scarcely distinguishable from, mere accident or want of foresight. The division has been adopted by common law lawyers from the civil law. Though the civilians generally agree in this division, yet there are not without a difference of opinion. These principles establish different rules have been made as to the responsibilities of parties for their faults in relation to their contracts. They are reduced by Potier to three. First, in those contracts where the party derives no benefit from his undertaking, he is answerable only for his gross faults. Second, in those contracts where the parties have a reciprocal interest, as in the contract of sale, they are responsible for ordinary neglect. Third, in those contracts where the party receives the only advantage, as in the case of loan for use, he is answerable for his slight fault.